Hello, everybody. Thank you so much for watching our video. I'm Cathy Naiser. I am a realtor who happens to work a lot with people in the estate sale process and probate process. And I've got here my friend and wonderful attorney, Mike Ezzell, who specializes now in probate and estate planning. And we're going to answer some questions today about navigating the probate process in Texas. So I'm really excited about this video because I think there's a lot of misconceptions. I think it's going to help a lot of people. So, Mike, can you just take a minute and tell us your background as an attorney and what made you become involved with probate law in the first place?
Thank you, Cathy, and thank you for having me. Well, I actually started out my professional career as an engineer many years ago. I had no thought about going to law school. I became an engineer for Shell Oil Company. They actually sent me to law school to become a patent lawyer. So I was a patent lawyer with Shell Oil for a while, and then decided I really wanted to go into private practice, so joined a firm in San Antonio. And for the next 30 years or so, I was in the courtroom a lot, mostly all the time, with various types of cases involving product liability, trucking disputes, commercial disputes, contract disputes, that sort of thing. And then formed my own practice a few years ago and found out that there was a need from a number of friends and acquaintances for probating estates, for drawing wills, drawing estate documents, and that sort of thing. And I just found I really enjoyed that type of practice because of the clients that I was able to help out, and the clients who came to me with a real specific need that I could address for them. So it's been a very rewarding practice for me to be able to help people out like that.
Awesome. So let's start with the basics. Break down the probate process. What is it actually, and why is it necessary? And then maybe the steps in Texas for probate.
Yes. So first of all, probate is the process of coming up with a mechanism for distributing a deceased person's property. That's what it's all about. Is how do you bring an orderly end to a person's property, a person's assets, and orderly distribute those assets, orderly pay any debts that are due as a result of the death of that person, or that person may have accumulated during the person's lifetime. So the probate is the process of allowing all that to happen in an orderly and legal manner.
Okay. And what are the steps in Texas to do that?
So yeah, talking about Texas specifically, because Texas has developed a very streamlined process of probating estates, especially probating wills, but also probating other estates as well. And I've had many clients who've come to Texas from, let's say, California and New York, who don't have nearly the streamlined process that Texas has, where probating an estate may take 18 months or 2 years. In Texas, it can all happen within months. It can happen within 60 days to maybe 120 days. It may be longer if it's a complicated estate, but generally it's much shorter. So the process of probating a estate is focused very specifically on probating a will or probating an estate without a will. And there are significant differences that take place in that situation. All counties in Texas have either a specific probate court, because it's a very specialized area, or they have a specific court that is designated to handle all probate matters for that county. So it's not like you can go down and file a cause of action in a district court or some other court, because there are, once again, specialized courts and specialized judges to handle probate of estates.
So you mentioned two different processes for probate. One was, or procedures, one was with a will and one is without a will. Are there any others, or?
There are other subcategories within those two categories, but the primary division is will or no will, because there are significant differences that take place if there's a will or if there's no will.
So somebody gets named as an executor, usually in the will. What responsibilities does that person have during the probate process?
Very good question. The executor who's named in the will, and also I'll talk to you in a few minutes about the category administrator, sometimes like an executor, sometimes different than an executor, but the same basic duties. And that is to gather together an inventory of all the assets of a person who dies, number one. And number two, to gather together all of the debts that are owed by that individual, either because of debts that have accumulated as a result of hospitalization, medical bills, or other debts, credit card debts, real estate debts, any other debts, any other expenses owed by that individual at the time that that individual dies. And then the executor or administrator is to pay off the debts with estate assets, if there are sufficient assets, and then distribute the estate assets that are remaining to the individuals that are named in the will as beneficiaries.
I think one of the tasks that people don't think about much is that inventory of assets and debts. It's something that is, time consuming if nothing's been done to organize, and sometimes people pass away and their things are just in a state of an array, a mess and chaos. So that inventory of assets, I know I have a checklist that helps with that. I also have a spreadsheet that can help with assets and debts, just help jog your memory. If anybody needs that, definitely contact me. But how are the beneficiaries notified and involved in the probate process, or are they?
They are very much involved. And once again, there are different procedures that take place if there's a will or if there's no will. If there's a will, we know who the beneficiaries are. And so the process of probating a will and the executor is going to be the applicant for probating a will, is to notify all the beneficiaries, to give them legal notice of the filing of the probate of the will, and to give them an opportunity to intervene if they want to intervene, or to give them the opportunity to waive intervention and allow the probate process to go forward, so that at the end of the probate process, they get access to that inventory. They find out what are the estate assets that are available to distribute, and they get access to the will, of course. They're provided a copy of the will. And so they know ahead of time what are estate assets that they would be entitled to under the terms of the will.
So let's talk about if the deceased did own real estate. One of the things that people say to me often is, I can't do anything yet because I haven't had my court date. And as soon as I have my court date, so they're waiting for the court date. Well, once it's filed, what kind of thing can the heirs do while they're waiting, or should they do with real estate while they're waiting for the court date?
Well, the probate judge has certain tools available to the judge to allow the property not to be diminished. And generally what happens is during the course of that time, before there's a hearing and before the judge appoints the person as executor and gives that person the power, steps can be taken to preserve the assets, either to preserve such things as simple as continue mowing the yard, continue maintaining the house, continue paying the insurance, that sort of thing. That can all be done to maintain the property, but what can't be done is no steps can be taken during that time period to diminish the property or to sell the property or to change the property, because there is no legal authority for the executor or anyone else to take those steps until they have been appointed as executor by a probate judge.
They can't go in and start rehabbing it.
No.
They can do inventory of assets and things in the house. And I heard you say they can take care of the property, and they should pay hazard insurance and mortgage insurance, or mortgage payments.
Yes, because those sorts of things would create would create a hazard that the property couldn't be maintained, and it would allow, let's say, a mortgage company to try to foreclose on the property, or it would allow an insurance company to go to the mortgage company, have the mortgage company purchase its own insurance. So lots of things can happen that would be more expensive for the beneficiaries, and that they have the opportunity. They can step in and say, well, we're going to do this to make sure that that doesn't happen.
Yeah. And yeah, I know for sure if the insurance company has a mortgage company start paying the insurance, it's more. It's a lot more.
A lot more.
So it better to you just to keep that homeowner's insurance going.
Yeah.
So what are some of the common misconceptions that you encounter about the probate?
Well, one of the things was we just touched on a minute ago, and that is after a person dies, what happens? Let's say right now we're talking about probating a will, where an individual has put down in a will of what that individual wants done with the property. Okay, so but just because that individual makes that statement in the will doesn't mean it's self-executing. It doesn't mean that the family can get in to the house and start divvying things up, because there's no legal authority to do that until the will has been probated and until a probate judge has appointed someone as independent executor or executor of that will. It's only after that point that the assets can be distributed among the beneficiaries.
That's one of the things I find is that people, when they don't have a will, the heirs just go in and start taking stuff. So from what you're saying, it sounds like if they don't have a will, you should probate it anyway. Or go to probate
Yes,
and then let the judge dictate who's going to get what or how that's decided.
that's right. Because if there's no will, then there's a little bit different process that takes place with a probate court in order to appoint someone who's going to have the authority to administer the estate and to pay off the debts, and then to decide who are the heirs. Because one of the I guess side effects of not having a will is that the judge appoints an individual, an attorney, to find out who all the heirs are. And there's actually a judgment that's entered by the judge. In addition to the appointed administrator, the judge enters an order and declares who are the heirs who are going to receive the benefits of the estate.
So this attorney ad litem, I think you called it on one video, is appointed by the court to help figure out some of those things, and then that is paid by the estate.
Yes, the attorney ad litem is appointed by the judge, and that's a position that occurs when there is no will, and that comes out of the estate assets, so it's an expense of the estate. And that attorney's sole job is to find out, are there any unknown heirs out there that we don't know about, and are those people heirs that are to receive benefits pursuant to the laws of the state of Texas? And if so, what percentage or how much are they going to get?
Yeah. And if somebody had 3 kids here and 4 kids there, it could get kind of crazy with all of that too. Another reason to have a will. So watch our video about wills. So what are the potential costs associated with probate?
Well, once again, it differs markedly if there's a will, if there's not a will. If there is a will, there is a process in Texas that takes place that is a very straightforward process of filing the will, filing the application to name the executor. Hopefully the will has indicated that the person can serve without bond, because if a bond is necessary, then the bond can be expensive in itself. So we want to make sure that the will provides that the individual is not going to have a bond. Then it goes through a process that takes about 6 weeks to 2.5 months for the judge to finally get everything in order to actually enter an order appointing the individual as independent executor. Once that happens, then that individual is empowered with a document called letters testamentary, is empowered to act for the benefit of the deceased individual, signing documents, transferring title to property, transferring financial accounts, transferring automobiles, titles, that sort of thing. So the individual is empowered to do that once that individual is appointed by the judge.
And you
Now,
said that can be the executor on a will, but it's not necessarily the one?
no, it would be the executor on a will.
Okay,
Then the other side of the coin is what happens in the event that there is no will. And
got it.
the probate process is going to be longer. It's going to require the appointment of an attorney ad litem. The attorney ad litem is going to have to do research to find out if there are any unknown heirs. The attorney ad litem then files a written report with the judge. All of these things take time, right? There are also additional witnesses that need to be found who can testify to the family makeup and to who would be the heirs of the individual the heirs of the individual who's passed away. So all of that is testimony provided to the probate judge. So it's probably 3 to 4 times the amount of work that goes into probating an estate where there is no will compared to probating an estate where there is a will.
So get a will, probate process is not as much money. Don't get a will, probate process could be a lot more expensive and very complicated.
Very complicated and take a lot more time.
Yeah. So it could last longer before anything can get done.
Right.
So, in order to probate a will or go to probate court, in Texas, do you have to have an attorney?
Very good question. Unfortunately, you do. Unfortunately, you do because, and the reason for that is this, because if you are seeking to probate a will or probate an estate, you're not doing that for yourself. You're doing it for others. And so a court in Texas does not want to allow an individual who is not a licensed attorney to, in essence, represent someone else in the probate court, because the Texas courts have said that that's one area where they require that a licensed attorney handle it, because that attorney is not just doing it for himself or herself. The attorney is doing it for others, and so it's in essence representing the interests of those others. And that's where the attorney-client relationship comes in.
So what should individuals look for when choosing a probate attorney?
Well, I think they would want to choose someone who they're comfortable with. Obviously, it's like any other trust relationship. The relationship between an attorney and client is a relationship of trust, and so they want someone that they feel comfortable with, that they can talk to, that is accessible, and they find trustworthy.
So let's talk for a minute about estate planning. So how can good estate planning in advance make that probate process more streamlined?
Another good question. So the estate planning process involves not just encouraging people to have a will, because that significantly reduces the cost and reduces the complication and the time, and also allows for an individual who passes away to have that property distributed the way the individual wants that property distributed, and not the way Texas decides the property is going to be distributed. But it involves other documents as well. There are actually other estate planning documents, many of which deal with situations when a person is still alive. There are 2 of those documents that deal with the situation once a person has died, and that would be, of course, the will, which is by far the most important. But also there's a document that allows the individual to express his or her wishes about what should be done with the remains. All the way from in a particular burial place to with some sort of prepaid plan, to a ceremony. So those are documents that deal with what happens when an individual has passed away. There are other documents that deal with temporary situations that allow an individual to name others, once again, people that they trust, who can take over for them either their health needs or their financial needs in the event they have a situation where they're temporarily unable to take care of themselves.
Yeah, that's a situation I see people get into, that but just because they don't do planning in advance for that, and then it's hard for everybody. So Let's go back to probate process for a minute. What happens if during the probate process there's disputes between the different beneficiaries?
Well, if there are, that's what the probate judge is there for. If by chance the will being probated or the estate being probated is one where all the individuals haven't agreed to a certain type of process, then those individuals have the right to intervene in the probate proceeding themselves, once again with an attorney, to make their position known. And so then the judge can either on an informal basis or a formal basis with a full-blown trial can make some determinations about how the assets should be distributed based on all of the input and the evidence presented to the judge.
So some of the beneficiaries can hire their own attorney and intervene in the probate process.
That's yes, they
Okay.
can and not frequently, but they do.
So what advice would you give someone who's about to begin the probate process?
Well, first of all, once again, it's going to it changes depending on whether there's a will or there's not a will. So if there's a will, then we know who the beneficiaries are, and generally we'll know how to contact those beneficiaries. So it's going to be more a matter of working with the person who's been named as executor in the will, who hopes to be appointed by the judge as executor, working with that individual to contact the beneficiaries and begin working through the process of distributing the assets of the estate and paying off the debts of the estate the way that the will lays out. Okay, and also if there are disputes and we have a will, the probate court allows what's called a family settlement agreement. So a lot of times, and I've had many situations like this where the family gets together and says, well, we believe that we can agree on a different distribution of the estate than what the individual has said, and we think it's going to be a more fair distribution because some of the family members may have died or may have changed circumstances. So the court allows for minor changes to take place if the beneficiaries to get together and say, this is what we would like. So they sign a contract. And so that takes the place of the will distribution. The same thing can happen if there is no will. You mentioned beneficiaries having disputes, and that frequently happens where there is no will because the person who died has not had the opportunity to express on a document what that person wants done with the estate. So obviously the beneficiaries may have their own ideas. They may say, well, I was the one who took care of him or her, and so I really should be entitled to a higher percentage of these estate assets than the others. And that's all well and good if the others agree to that, and that has happened before. But if they do, then once again it's a contract signed by all the individuals who agree on a certain distribution.
I think it's always interesting because most people think, oh, my family's going to do fine after I pass. But once somebody passes, especially if there's money involved or property, things change. People change and people behave in ways you probably would have never expected. So again, one of the best ways is just to have a will from the beginning that's done the right way because Texas has its own way of doing wills. It's not like you can go buy one in Office Max or whatever and have it expect to hold up well in probate court. What resources or tools, if any, can you recommend for individuals going through the probate process?
Well, what I generally do when a client approaches me, I have what's called, and other probate and estate attorneys are going to have very much the same thing. I have a fairly short document I call an estate planning questionnaire that lays out all of the estate documents and lays out the individuals that are needed to be named in the different documents, including the will, lays out the beneficiary designations, and kind of gives some food for thought about how to make those decisions. And that's a document that we frequently have filled out as the first document. As far as where to get information generally, obviously the internet's a good source. I mean, there are certain principles that are kind of universal on distributing estate assets that people may decide to adopt or not adopt, but it helps to read about them.
Sure. And in the probate process, I know I have a few forms. I'm not an attorney, but I've got some checklists and reminders about asset inventory and the probate process. And I've got actually, it's a spreadsheet I found on the internet that looks pretty good that has the inventory of assets and debts. So you can always contact me, and I'm happy to help forward you things that I've found that are helpful. So is there anything else before we kind of start bringing this to a close that you would like our audience to know about the probate process in Texas?
I think the main point is how, and this is based on information I've heard from attorneys in other states, is how streamlined the process is in Texas and how simple it is. Because I've had many clients come to me and say, well, I really want to put together a trust to distribute my assets. And so I explore that with them in detail, because what I find oftentimes is they don't want their surviving heirs to have to endure the expense of a very, very expensive, time-consuming process. But that just doesn't happen in Texas. So I think one of the biggest points I would want to make with individuals is that the process in Texas is very quick and streamlined, and even if you don't have a will, it is streamlined over what it would be in some other state. So it's important to keep that in mind, and also to kind of keep in perspective, as far as it's going to be an expense, but it's an expense that, if compared to other expenses that we see time in and day in and day out, and year in and year out, it's an expense that is not a necessary expense, but certainly an expense that is meant to serve a very useful purpose.
Yeah, and I can kind of echo that. I network with real estate agents across the country, and in some states, 6 months to a year period for the probate process. And in Texas, it could last longer, especially, without a will, if it's complicated. But, the process in Texas is much quicker, much more streamlined. I think one of the best ways to navigate it is to go into the process with a will, which is another reason for everyone on the planet to have a will if they're after
Absolutely.
18 and they have property. And we did a whole video about that, and you can watch that on my YouTube channel, or ask me for a copy of it. So, Mike, why don't you tell us how people can get in touch with you and your firm if they have any questions about wills, estate planning, or probate?
Yes, thank you, Kathy. I'm going to do a screen share here that gives my name, my email address, and my telephone number. And if individuals would like to get in touch with me, please reach out to me at either my email address or a telephone number. And I would be more than happy to answer any questions that they have, or to walk them through the probate process, or just to spend some time just furnishing them the information that they might need.
Awesome. So, and I'll let that play a little bit too. Again, my name is Cathy Naiser. I am a real estate agent. I do real estate in Bexar County, Comal County, Guadalupe County, and surrounding areas. I do all kinds of real estate, and I find myself specializing more and more in probate. You can go to my website, Alamo Probate Services, for more tips and tricks and resources and facts and things like that, all about the probate process. And certainly, if I can help you in any way, let me know. Just look at the banner for my phone number. And I want to thank again Mike for taking the time, a busy attorney, to join us to provide information so that you all can learn about the probate process and maybe not be so scared about it, because it really is very streamlined in Texas and very easy to navigate when you have an attorney and things are set up right. So any closing comments, Mike?
Only to thank you for allowing me to do this, Kathy. Thank you very much. I really appreciate the opportunity, and and I look forward to helping out any folks who contact me.
Great. And I look forward to us doing more interviews. So have a great day and thank you so
All right.
much.
Thank you, Cathy.